self-assembling structure.
Verzweifelt.
The World Economic Forum's Young Global Leaders.
Injured, or at least temporarily, got very sick.
They were trained to ignore their own judiciary.
Good morning. This is another impromptu session of the International Crimes Investigative Committee. We do these kinds of things when something really important comes up that needs to get to the attention of the public as quickly as possible. Today, we're going to be speaking with Kip Warner about a very important lawsuit that is pending in British Columbia, in the province of British Columbia in Canada. Good morning, Kip.
Good morning, Reiner. Thank you for having us.
Well, it's a pleasure. We've known each other for almost 3 years now, 2.5 years. We haven't met physically yet, but the time will come. This, however, is what has been on my mind for a long time. This case has been on my mind for a long time. You kept updating me about this case. So what is it about? Who's bringing this case? And what are the facts of the case, and what are the legal problems that we may encounter?
Sure. So some background. I'm in Canada, a city called Vancouver, which I'm sure a lot of your listeners are familiar with. And it's inside of a jurisdiction called British Columbia. It's a province. So in the United States, they have different states. In Canada, we have provinces and territories. And I'm over on the West Coast, British Columbia. And what we did was we wanted to challenge the declaration of an emergency, which is sort of the underlying premise for all the different public health measures and private sector mandates as well. They were all predicated on that declaration of an emergency. And so back in, I believe it was December of 2020, November, December, I was lobbied by our community to start a campaign to challenge through the courts these mandates. And the way we went about going and doing it was we incorporated a nonprofit here in British Columbia to act as the representative plaintiff in a class proceeding brought against our provincial health officer and the provincial crown. And we began that, or we filed on, I believe it was the 26th or 27th of January, 2021.
Mm-hmm. So this has been pending for almost 2 years now. Who will be able to join the class when it comes to trial?
So for those of you who maybe aren't familiar with class actions, there's usually two different types of jurisdictions that deal with class actions. There's automatic opt-in jurisdictions and the opposite. So here in British Columbia, I believe in Quebec, I think in California as well, if someone brings a class action on behalf of people who purchased, let's say, a defective product, or there was a vehicle recall or something like that, they're automatically in that class. They don't need to take any positive step. They don't need to send a letter or click a button or something like that, provided the suit is certified as a class action by the courts. Everyone affected is automatically in there, as opposed to the opposite, where you'd have to take some sort of manual step. Does that make sense?
It makes perfect sense. In other words, anyone who is a member of the class is automatically in that class. If they don't want to be a member of that class, then they can do their own thing, right?
Correct. And thus far, we haven't had anyone want to do that. But usually that's in very rare circumstance, like they may have been already prosecuting their own claim. And for whatever reason, maybe there might be some procedural complications. They want to go off and do their own thing. But we have a province here of over 5 million people. And so basically everyone who was affected adversely by the declaration of emergency is part of the class. And we have various subclasses that we're in the process of refining right now at this very moment. People who maybe weren't allowed to attend certain religious gatherings, or their businesses might have been affected, or they were required to do certain things that they wouldn't have otherwise been required to do had it not been for this declaration of an emergency.
The declaration of an emergency is the basis for all of the measures that we've seen. We know that this declaration of an emergency, the WHO calls it a public health emergency of international concern, is based upon only PCR tests. Does this play a role in your case as well?
Yes, it's instrumental. We've been receiving large flow of documents from our stakeholders, whistleblowers, people inside the provincial government and elsewhere, with documents about the PCR test, how it was used, what was known specifically by the defendants. And that's pretty instrumental, as you know, for challenging the declaration of an emergency. I think Drosten and others and the test itself have been discredited. I don't believe that they're even recommended anymore by the WHO. But the point is, at the time of the declaration, at the peak of the hysteria, the PCR test was considered the gold standard, as you'll recall. And so that's pretty important that we challenge that. So BC, like any jurisdiction, is made up of many different demographics. There are people who are affected by these mandates in different ways. As I alluded to earlier, some people, they weren't able to attend certain religious gatherings. Other people can go into restaurants or pubs. They couldn't see a film. I wanted to see Dune. I couldn't see that in theaters. Everyone was affected in different ways. And rather than bringing a challenge that specifically targets each one of these policies or on behalf of a particular demographic, it made better business sense to challenge the underlying premise in which all of these different public policy and private sector mandates were predicated on. So the example I like to use is if you've got a big rotting tree in your yard, you want to get rid of it, rather than plucking all the leaves off and starting there, you go to the root and you start there and then you remove the tree. That makes more sense. So if we succeed in challenging the declaration of emergency, then basically everything that was dependent or flowed from that falls apart one way or the other.
That's exactly my approach too. So when you're saying that basically everyone was affected in the province of British Columbia, was affected by this declaration of an emergency, they were affected by the measures, the mask mandates, the implicit vaccine mandates. I know there weren't any real actual mandates, but as just like everywhere else, including Germany, including the United States, the employers, especially those who employ members of the healthcare community, they applied enormous pressure. And this wouldn't have happened had it not been for the declaration of this emergency. So if you attack at the root, everything will come crashing down. Everything will be deemed to be illegal, in my view at least. Does this mean that potentially everyone in British Columbia could be a member of this class?
Yes. Yes, in short.
Because they're all affected. In some way, they've all been affected.
Our judge has recently said that in one of his rulings, procedural ruling along the way, that there isn't a single person in this province of over 5 million people that hasn't in some way been affected by COVID-19, the policies, and so on. Everyone. So we actually did have an injection mandate here in BC, and like you, so it was not for everyone. It was for healthcare workers, and there may have been others in other places as well, and there certainly were in private sector as well for certain employers that wanted that. Like you, I use the neutral language of injection because it's controversial on whether or not it actually is a vaccine, but these injection mandates for healthcare workers here in BC were quite serious. As a matter of fact, there was a report recently released, I believe it was in the True North or one of the online publications, across Canada. I mean, we had healthcare shortages and staffing shortages in the system long preceding the declaration of an emergency. Like in many jurisdictions, we have problems with inadequate healthcare resources. although Canada has a universal healthcare system, it has its shortcomings, and one of them was a lack of people. And with the injection mandates, about 10,000 nurses and other healthcare workers across the country lost their job for refusing to submit to these injections. And you just do a rough back of the napkin calculation. If a nurse has been out of work for a year now and they make average, say, $100,000 a year, that's $1 billion in damages just for nurses. That's just one particular demographic. So there's a lot at stake on being able to successfully challenge this declaration of an emergency, because we think that the best safeguard to prevent something like this happening again is case law.
Absolutely. I agree with that. Now, I think this case has ramifications that go way beyond the province of British Columbia, because if there is a ruling that says that there was no emergency, and I believe there was no emergency from all the facts that we have learned through the work of the Corona Investigative Committee, from having interviewed over 400 experts from all over the world. Now, if the court comes to that kind of a conclusion, there was no emergency, maybe even there was a fake emergency. Maybe the hearings will come to the conclusion that the PCR test was abused intentionally in order to create cases that otherwise wouldn't have existed. I'm pretty sure this is going to go way beyond the province of British Columbia. This is going to have ramifications throughout the entire world. Just like most of the other cases that have made headlines. For example, the case that was decided by a Florida federal court on April the 18th of this year, saying that the government, in this case the CDC, doesn't have the authority, doesn't have the power to issue mask mandates. This case was seen and heard all over the world. For one important reason, though, the people reacted to that ruling, reacted very positively. To me, this was the most important result of that case, that the people were celebrating, openly celebrating on the planes. Captains were coming into the cabin celebrating with the passengers. And this was seen and heard everywhere. And it told you the true story of what's really going on. In this country, at least in the United States, a majority of the people doesn't want the measures. Now, if this is what's going to happen in British Columbia, and if the public responds in a similar way, then this ruling, I'm pretty sure, will have an even more profound effect on the people. It's about, as far as I'm concerned, it's not just a legal decision. It's going to be about empowerment, because this is what this is all about. It's the people fighting back against measures that they believe are unconstitutional, illegal, and have no factual foundation. That's why I think this is the most important thing that I've come across in the last 2.5 years, because it goes right to the heart of the matter.
Yeah, that's what a lot of people, other members of the bar like yourself, have been saying is the way that we're going about doing it is unique, and it's a high stakes game, but really the only way to get lasting progress, meaningful progress, is, I think, to challenge the underlying premise. Because, like, even as you said, there have been a number of successes in various jurisdictions, in particular in the States, regarding mask mandates and so on. But even then, they're technical successes. The court isn't asked to examine the underlying premise. It just said that someone acted ultra vires outside of their mandate or something like that. And the problem with technical rulings is that they're fragile. It leaves the world in a precarious state. There is no security about what cannot happen tomorrow. And imagine, like in Canada, in the British system, the executive does have more power than in the States. The United States is, it's the world's most powerful military force. But actually, the Prime Minister of Canada has, as a member of the Executive Council, he has more power than the President of the United States over his own country. And that's a problem. That's a problem here, because if you ask that it's built into the system where our public officials do have extraordinary power, but it's still there's checks on that. The decisions that they have to make have to be reasonable. But if you always try and challenge, like say a mask mandate here in British Columbia, the problem is that the courts will, if they take judicial notice of an emergency, they will say that the executive does have these powers to respond in extraordinary circumstance. And so that's why you have to pull the rug out from underneath and go to the very bottom. It's just, my background's in computer science, but I did a lot of philosophy when I was in school. And so I understand the architecture of an argument, and that's the Achilles heel. That's it. It's the declaration of emergency.
Absolutely. Now, as opposed to the Western European countries plus Turkey, the ruling that I just referred to, the anti-mask mandate ruling from the federal court in Florida, was immediately acknowledged by the government. They didn't dare ignore it. We've had PCR test decisions in Europe. The first one came from a very well-written decision from an appellate court in Portugal. The second one came from Vienna in Austria. The third one came from Weimar, of all places, in Germany. And the fourth one wasn't a European decision, but it's a Turkish decision. And each and every one of them said that the PCR test, just like its real inventor, Kary Mullis, a Nobel Prize laureate, has always said the PCR test cannot tell us anything about infections. And that's why it's not even authorized for diagnostic purposes. No one seems to understand this, but this is what it used to say, and probably still says on the inserts. But it was still used as the gold standard, as the WHO said, for the detection of infections. Now, because I would say the puppet of the World Health Organization, the aforementioned, you mentioned him, Drosten, a fake professor and a fake doctor from Charité University in Berlin, because he pushed this. And that's when the WHO used it as a gold standard for the entire world. Everybody else took this recommendation seriously and used the same ineffective tool. Now, in the three European countries, Germany, Portugal, Austria, and in Turkey, the rulings all of them were very well written, but the governments didn't care. I have learned in the meantime that these governments are not our governments, but rather they're creations of the World Economic Forum's Young Global Leaders program. So they were trained to ignore their own judiciaries. This did not happen in the United States with that decision, with that anti-mask mandate decision. How's the situation in Canada or in the province of British Columbia? What can we expect if such a ruling in favor of the plaintiffs came down? Would the government, the provincial government, respect it or ignore it?
I don't think that they would have any choice. I think it's not a question of what they want to do. Like, we know what they want to do. It's to continue doing what they have done. But the problem is that if they're in contempt of court, then that opens them up to all kinds of civil proceedings, and there's not really any defense for that. Or the government's breaking the law; it's breaking the law, and people are entitled to. For example, in our case, we have a constitution, just as the United States does. Not all countries do. Like the Brits don't have a constitution, but we have one that's written down just like you. And part of that constitution, 1867, is a component that was added in, I believe it was 1982, called the Charter. And the Charter is basically about human rights things. It's you could call it. It's a safeguard, basically. It sets minimum standards for government, what things that it cannot do. And you have the right to life, liberty, security of the person, freedom of association, things like that. And charter, if the government violates your charter rights without a good reason for doing so, and that reason is taken out without a declaration of emergency that was based in law, in fact, then anyone affected by that is entitled to charter damages. And everyone in Canada is entitled to the Canadian Charter. So even if you're not a Canadian citizen, but you happen to be here in Canada, the Charter still applies to you. It applies to all government institutions in our country. The Charter applies to, and it's pretty foundational to how things work in our country. And in fact, a lot of people didn't even know we had a constitution. That's the good thing about all of this. COVID has taught people in our country a lot about their legal system, the judiciary, sort of who has power to do what, how, and to what extent. And before that, people didn't know about our constitution. They didn't know about the Charter. Like a lot of people, they watched a lot of American TV, and so they knew all kinds of biographical minutia about this or that American judge, but they knew very little about what went on in their own country. And so in that sense, it's a good thing that it's one of the only good things, I suppose, is for everyone who missed out on the basic civics, they're learning it now. It took a national disaster, but that's one good thing.
Same in Germany, pretty much same everywhere, all over the world. The underlying problem that this question touches upon is, or it's not a problem, is the separation, the idea of the separation of powers. You have the electorate, the legislators, you have the administration, the government, and you have the judiciary. And each one of these branches of the government should respect each other. That's why I find it extremely disturbing to see what happened in Europe and in Turkey, to see that the government, the administrative state, as some Americans see it, rising up, that the government doesn't care about what the judiciaries are saying. And I'm very pleased to hear that this is not a real danger in Canada. Hopefully, if and when your case gets that far, hopefully, when there is a decision in favor of the plaintiffs, the government will then respect it. But that's the way it should be. One shouldn't even have to think about it. But judging from the experience that we had in Europe, you have to expect the worst. But this is different. I realize that. That's why I've always said the Anglo-American legal system, in particular the American and probably the Canadian as well, they're not that much different. That's the only real hope when it comes to a legal fight, a courtroom fight against these measures. It's the only real hope. Those are the countries that have a real law of evidence. You have class actions. And in the United States, I'm not sure about Canada, in case you can prove intent, you can easily walk into punitive damages territory. And that's what it takes in order to take down those who are really responsible, these large corporations.
Yeah, and that is, you're right. In the States, they have, in different jurisdictions in the States, they have some kind of a civil mechanism for bringing a class action. Canada, obviously, as well. We've got that here in BC, Quebec, and other places too. But that's not something to take for granted. As you know, like in Germany, there isn't in common law or something, but I don't believe there's any statute for bringing a class action.
No.
I'm not sure why.
You can't do that. It's because of the lobbies. Europe is totally under the thumb of the people who are behind this. Right. If you believe that someone is behind this, I believe this is not an accident. There's no mistakes that were made. This is a long planned agenda that's being carried out. I used to be a member of what they claim is the largest anti-corruption nonprofit. It's called Transparency International. And in that outfit, I was the leader of the working group of the judiciary. There's other working groups, healthcare working groups, et cetera, et cetera. And we tried to introduce, there were lawyers, law professors, judges, prosecutors. We tried to introduce class actions into the German rules of civil procedure. However, we were infiltrated by someone who was working for the large global corporations, and he blocked pretty much everything. So eventually, we had to give up on this endeavor, not because we wanted to, but because the leadership of this Transparency International simply canceled our working group, caved in to the lobbyist demands. That's what's so important about this thing. It's the lobbyists who, in Germany at least, probably in many other parts of Western Europe as well, the lobbyists, the industrial lobbyists, have complete control over our legislators. And the legislators rather, do have, through the presidents of the courts, have a way of ruling directly into the courts. It's not being done in an overt way, but you can see what I mean. Now, I'm glad that this is not happening in the United States. It's not possible in Canada either. So what is going to happen in the week starting on the 12th? What are the hearings about?
Right. And so we have a very important hearing that's coming up, called our certification hearing. And so what that means is, in a class action, and I'm assuming it's similar in the States and in other jurisdictions that have some sort of a class action statute, basically what happens is, before you are certified, your suit is just a normal suit. It's whoever versus whoever. But what certification does, it's a process by which a judge reviews your proposed class members, the definitions, whether there's a common issue to be tried, and various other technical tests that have to be met. And if satisfied, the court certifies your suit as a class action. So before then, it's simply a proposed class action. It's brought under the Class Proceedings Act. But until it's certified as such, it's not actually. And certification is very important in a class action, because in a normal suit, you have one party sues the other side responds, and then there might be some applications to throw it out or whatever, but there's a discovery process that takes place, or supposed to take place. And obviously you're quite familiar with this, but for your viewers, what the discovery process is it's an opportunity for the parties to learn about each other's strengths and weaknesses of their case. And that means producing documents, compelling witnesses to provide testimony, and so on under oath. And in the States, they call that a deposition. In Canada, we call it, or in BC and probably other jurisdictions, we call it an examination for discovery. And that's a very important tool in the civil justice system, which we set out with two goals when we started off our campaign. One was answers, and the second was accountability. Accountability is determined by the trial judge, but answers, we will have achieved half of our objectives if we get certified, because if we get certified, you then have the tools of discovery. So that's the thing with a class action in BC, you don't have discovery right away. You have to get certified. So it's a very powerful weapon, a class action, but it doesn't have the agility necessarily of a smaller a suit of only a few people suing a few people. And that procedural hurdle is essential in order to have the tools of discovery, because once we have that, then we can subpoena, or in fact, we don't need to. Under the civil rules, our public health officer is required to testify. And then we can ask her questions, anything related within the scope of our suit. So we have a thing in the British system called cabinet confidence, and it's probably similar in the States, executive privilege, where basically what goes on in Vegas stays in Vegas for X number of decades. So the people are our most senior level public policy makers, cabinet level, their notes of the minutes of their meetings and so on, those discussions, they're all, you'd say, classified in some sense. The public doesn't have access to them. If you try to submit a freedom of information request, you won't get anything back, nothing useful at least. And that's a problem because, well, we'd love to ask our cabinet level people why they made the decisions that they did. But in BC, our public health officer she's supposed to be independent of cabinet. She's supposed to provide independent medical advice. She has the power to create public health orders, to basically lock down the province, tell everyone to stay at home, wear masks, wash, all these things, right? And because she's not a member of the Executive Council of Cabinet, she cannot claim privilege, cabinet confidence when we ask her questions. And if she does, it begs the question, well, why was cabinet telling you what to do? You're supposed to be independent of cabinet. Now, you and I both know that all these different public health officers and all these different jurisdictions were all basically doing the same thing. And obviously they were answering to someone. And that gives us an opportunity to find out who during the discovery process. The work that you've done has been instrumental internationally, whereas what we're doing is focused primarily on British Columbia, on it's technical, it's procedural to get to the stage where we're at. But because of the work that you've done, if we get certified, as you know, we've engaged you to assist us with the discovery process if we get there. That's really important because you can bring a wealth of knowledge and experience in providing sort of the geopolitical context to help alleviate the enormous burden of discovery. I mean, we're expecting hundreds of thousands, potentially millions of documents, but you will know exactly what we need to be looking for. And that's why we've always had a productive relationship, the two of us.
And I'm really looking forward to that. Actually, all of us have very high hopes on this case. And I've spoken to a lot of people in Europe, in the United States now too. The Americans weren't even aware of this case. That's why this is so important. This impromptu session is so important to make people see that this is going on, and that with the right amount of professionalism and preparation and getting the right people on board, you can get very far. And if we're lucky, if you're lucky, then this case will actually get certified to go forward as a class action, and that's when the real action starts. And I think, as I said before, I think this will have immense ramifications. Look at your neighboring province of Alberta, for example, where the new premier, is it a premier or prime minister of the provinces?
Premier. It's like a governor in the States.
Yeah. So that new premier is very open to such discussions. And I would imagine that if that happens, if you're successful with that lawsuit in the province of British Columbia, then this will go like a wildfire across the entire nation of Canada, and then probably into the United States and the rest of the world as well. So that's why I think this is extremely important. And I know that a lot of work has gone into this, and I know you've been extremely transparent about what's going on because you've been keeping me informed, you've been keeping the public informed, and that's why I think it's now time, and this is the right time to bring this suit, because it's very obvious that some of the measures, I'm not talking about the mask mandates, the lockdowns, but I'm talking about the injections. It's very obvious that these injections, first of all, don't work. Well, first of all, they're not necessary because, as if we're lucky, will come out in this lawsuit, there wasn't an emergency because it was all based on a fraudulently misused PCR test. And if that is the case, then what the people are now beginning to realize that the vaccines aren't effective and they're extremely unsafe will finally have a remedy. And it'll not just be a remedy, but it'll stop this whole show. That's what I'm hoping for, really.
Yes. I mean, with respect to the injections, I don't know a single person who doesn't know somebody in their life who got the shot and is either now injured or at least temporarily got very sick, seriously maimed, or if they're really unfortunate, are no longer alive. And we all know people like this now. But with respect to the class action, I mean, it will have ramifications, not just for BC or even just the country, potentially for the world, because at the essence of the suit is we're asking the court to make a determination on facts, not just law. And as you know, each jurisdiction has different laws, but facts are facts. And since all the different jurisdictions declared an emergency based on what is allegedly science, and science isn't law. It's based on firsthand empirical observation, data gathering, formulating a hypothesis, making a prediction, refining it, having a theory. These things are universal. And so if we manage to obtain the kind of ruling that I would like to see happen, it will have ramifications globally. And that's why our work, what we're doing, is so important. It's difficult. I mean, we have a shoestring budget that we've been working on. I'm a volunteer. The team's all volunteers. We don't take salaries or anything. But it's very difficult to do something like this. And sometimes even I'm surprised that we've managed to survive this long, 2 years. I can't guarantee that we'll survive certification. But if we do, it's an opportunity for the whole world to celebrate.
Yes, and that's really important to point out. It's always the same set of facts that we're dealing with. No matter if you attack the mask mandates, the lockdowns, the social distancing, the injections, it's always the same underlying set of facts. And once these facts are established, even come to the conclusion that this was a fake pandemic, it was all based on a fraudulently misused PCR test, you don't even have to look into what's really behind this. But once you get to that point, then their whole house of cards collapses, not just in the province of British Columbia, but everywhere, because it's always the same set of facts, the gold standard for the entire world. All of a sudden, you don't have an emergency anymore.
Yeah.
Okay,
it was a pirate's gold standard, but yes.
Yeah. Very well put. Well, okay. I'm going to keep my fingers crossed, and I know our viewers are going to keep their fingers crossed because they know that maybe this has an effect on the entire world. Hopefully in a very positive way. And even if it doesn't, we're going to continue with what we're doing. There's going to be another challenge and another challenge, one step after another. But right now, I have very high hopes riding on your case, and I hope that I'm going to be able to help a little bit.
I hope so too. And anybody who wants to learn more, they can always go to our website, which is suebonnie.ca. That's the shorter version, SUE, and then Bonnie, BONNIE.ca. Or they can go to the longer version if they like, COVID Constitutional Challenge BC.ca. We had to shorten it because it's kind of hard to holler that out of a window and people remember it when they're driving. So.
Okay, well, we'll be in touch, and I will make sure that we're gonna post the progress of the case on our Telegram channels, on our website as well, because now that the people know that this is important, they want to know what's going on. And I am almost certain that this is going to have a very positive ending, a happy ending. Thank you very much. Yeah.
Thank you, Reiner.
Okay.
I'll see you later.
See you later. Have a great weekend.
You too.
Take care.
Bye.
Bye-bye.